Good morning, sir. Are you David Bullwig?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Let me get it pulled up the right way real quick.
Judge, what we're doing is pleading him to it's the same offense, deadly conduct, just under 22.05A, which makes it a Class A misdemeanor.
Oh, five.
This courtroom session quickly turns serious as Judge Boyd begins handling a series of very different criminal matters. The first defendant, David Bullwig, is facing a deadly conduct charge from March 20th, 2025, and the state proceeds on a Class A misdemeanor. He ultimately enters a guilty plea under an agreement calling for 1 year of deferred probation and a $500 fine. But the Raquel warning comes immediately afterward. Successful completion could lead to the case being dismissed without a conviction, while a probation violation could bring him back before the court facing up to a year in county jail. But that is only the opening case. Courtroom soon moves into a probation revocation hearing, competency questions, a felony injury allegation.
Mr. Boyd, in cause number 25 DCCR 0720, the state has elected to proceed on the lesser included offense of a Class A misdemeanor of deadly conduct, and that's from March 20th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablets some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Jeffries? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached is for a 1 year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Boyd is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, defer all proceedings and place you on probation for 1 year. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have conviction on your record. And at the end of the probation period, if you successfully complete it, the case will actually be dismissed. You'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the county jail for up to 1 year. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation's sitting at that desk right over there. She's going to call you up to her desk to go over all of your paperwork when she's ready. All right, good luck to you, sir. Thank y'all for working this out.
Thank you,
Thank you.
Judge. Thank you.
Yes, sir.
It's gonna be hard to get through a bunch of words. Hey, sir, are you Harold Denton?
Yes, ma'am. How are you?
Good, thank you. And Mr. Lewis, will your client waive the formal reading of the motion?
You do, Judge.
Mr. Denton, in cause number 21-37744, I have a motion to revoke the community supervision. Shows that you were placed on probation October 20th of 2021 for the offense of assault on a peace officer, a second-degree felony, and that was a 10-year prison sentence that was probated for 10 years. Is that correct? This motion alleges that you violated your probation. It alleges in count 1 that you failed to report to the probation office as ordered September 26th, October 17th, November 13th, and December 1st of 2025. And is that true or not true?
True, Your Honor.
Count 2 alleges that you failed to immediately report your home address and phone number also to the probation office as required. Is that true or not true?
It's true, Your Honor.
Count 4 alleges, I'm going to dismiss 3. Count 4 alleges that you failed to be placed on the mental health initiative caseload as ordered due to the fact that you absconded and you were unavailable for placement. Is that true or not true?
Yes, ma'am. That's true. I had
Count.
difficulties.
I'm sorry.
I had some difficulties. They stole my medications from my backpack at the bus stop, and I Just,
Okay. Count 5 alleges that you failed to successfully complete the BIP program. Is that true or not true?
the what program?
BIP, the battering intervention and
This is true, yes.
okay. Think with the agreement, if y'all are okay, that's fine.
9 was the failure to complete.
There we go. 9, count 9 alleges that you failed to enter and successfully complete the Safe P outpatient aftercare. Is that true or not true?
Aftercare is from, I successfully completed this, the
Right.
analysis.
This is just the aftercare. You got to do the whole thing.
Yes, ma'am.
All right. Did you enter your pleas of true to counts 1, 2, 4, 5, and 9 freely and voluntarily?
True. Right.
And did you plead true to those counts that you pled true to freely and voluntarily?
Yes.
Okay. And I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Denton is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 4, 5, and 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke the probation. Reassess your punishment in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. Well, his was in 21, and I think we started, I think it was 22 or 3 when I started reading it. So in my mind, if it was 22 or before, because I can't remember, I just do it again.
Yeah.
I can't remember the exact day. I know, and I need to say so many more words today.
That's what I was waiting.
Good morning. Are you Perry Hurd Jr.? I'm sorry.
Right.
Okay, and this is cause number 26 DCCR 0052. Mr. Hurd is charged with harassment of a public servant. I'm going to take judicial notice of the court's file. I received a report from Dr. Capon with regard to competency, and that report is dated June 23rd of 2026. The finding in the report is that Mr. Hurd is competent to stand trial. Is there any other evidence with regard to competency?
No, Judge. Not from the state.
Right, that at this time, based on that report, I am going to find that Mr. Hurd is competent to stand trial. And what is the announcement?
Judge, I have received a new offer this morning since visiting with Mr. Hurd in regards to his offense, Judge, and I think it's something that could possibly resolve this issue. If I can just get a short reset in so I can explain that and go over with
Sure.
Mr. Hurd.
You want a week or 2?
About 2 weeks.
Okay, we'll reset the case 2 weeks, Mr. Hurd. Mr. Lewis will be out there to go out and visit with you about all your options, and we'll get an announcement at the next court date.
This is the court date for today, right?
I'm sorry,
So this is my court date.
today's your court date, but I'm gonna move it for 2 weeks so that Mr. Lewis can spend some more time with you going over everything, okay?
All right, so I've been in there long enough to let's see if I need time served or how.
Talk to Mr. Lewis about all your options and he'll let you know what they are, okay?
Okay.
All right, he'll be out there to go over all of it and
So
make
this
sure,
is looking good for him.
he'll be out there to go over all that, okay? You can go back with the bailiff.
I'm gonna talk to y'all whenever.
All right.
No problem.
Denisha McMillan.
Yes,
Morning, ma'am. Are you Denisha McMillan?
yes, ma'am.
And this is cause number 26 DCCR 0647. And I'm going to take judicial notice of the court's file in Ms. McMillan's case. Ms. McMillan was evaluated for competency to stand trial by Dr. Capon. I received that report dated June 23rd of 2026. The finding in the report is that Ms. McMillan is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Judge.
Not from the state.
Then at this time, based on that report, I am going to find Ms. McMillan competent to stand trial. Mr. Lewis, will she waive the formal reading of the indictment?
She does.
Ms. McMillan, you're charged with a third-degree felony offense of injury to an elderly individual from March 16th, 2026. And how do you plead to that charge?
Plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
No, ma'am, I'm just ready to do my time.
Well, it doesn't work like that. If you didn't do this, then you get a trial. So here's the thing, before you go any further, when you stood over in front of the clerk a minute ago, you raised your right hand and you said you promised to tell the truth, the whole truth, right?
Yes, ma'am.
So if you're guilty, you're guilty. If you're not guilty, then we'll get your case set for trial, but I'm not gonna allow you to plead guilty with something you didn't do.
Yes, ma'am.
Okay, so if you want to talk to Mr. Lewis for a minute again, that's fine. If you're going to take responsibility, then I'll ask the same questions again, but that's going to be up to you.
Yes, ma'am.
What do you want to do?
I mean, I don't have anything to say with it. I know I never touched him.
Okay, so then I'm going to delete this paperwork, and what we'll do, Ms. McMillan, is I'm going to set your case for trial.
Yes,
When I set your case for trial, Mr. Lewis is appointed to represent you at this point. He handles a lot of cases for me here as a appointed attorney. With your permission, I can release him and I can appoint another attorney who could get ready for trial a little quicker. Is that okay with you?
yes, ma'am.
All right, then, Mr. Lewis, you're released. Ms. McMillan, we will get you an attorney appointed today. They'll be out to see you very soon to begin preparation for trial.
Yes,
All right,
ma'am.
you go back with the bailiff.
Yes.
And Mr. Smith, if you'll make a notation, make sure, obviously, that's. I mean, we'll see what the other attorney does, but I don't intend to keep that deal. I'm sure you don't either.
No.
All right, Kadesha Scott. Morning, ma'am. Are you Kadesha Scott?
Yes, ma'am.
And this is 26 DCCR 0797. Ms. Scott is charged with the first-degree felony offense of aggravated robbery from July 3rd of 2025. And what is the announcement?
Judge, in this situation, we have the complaining witness who's evidently been trying to get in touch with the state
Okay.
in regards with this issue. And actually, I talked to the complainant myself a few times where they've called me saying they've called trying to get in touch with the office. I've given them their number up there so he can get that taken care of. That's the main weight that we
Okay.
have on our end.
Sure.
And Judge, I mean, in the meantime of that, of course, I would like to possibly either, I know we may not be able to take care of it this morning, but at least get a bond hearing set for Ms. Scott until we can get that worked out.
Let's do this. I mean, is there any reason you can't try to get that worked out this week to get in touch with him?
This is a case I inherited from Mr. Coleman.
Okay,
The number that Mr. Lewis has for him is the number that we have in the file. We did send him a letter. Tommy sent a different letter than we normally send, and it was returned. So I don't know about the address, but the phone number apparently is good. I didn't have a message that he had called, but I will reach out to him.
okay. Let's do this. I'm gonna reset it 2 weeks, and that'll give Mr. Smith time to kind of get caught up, make that phone call, get in touch with them. If by that time, between now and then, if you want to go ahead and file a motion for bond reduction, that way everybody's on notice and we can have that hearing on that date if something else doesn't get taken care of.
Good.
Okay, all right, see you back in 2 weeks. Joshua Smith.
Judge, can you speak to somebody from?
Yeah, the hold him for us. Morning, sir. You Joshua Smith. And so, Mr. Smith, before you came out, Mr. Lewis explained that some of the hesitation you have, that there's an agreement that you guys have worked out that you're willing to accept, but you're a little concerned because Harris County does things differently, I think, than we do. I just want to let you know how we do things. And then if you want to enter that plea, you can. If you want to go to trial, you can do that, okay? What I do is if someone pleads to an agreed plea, I to take that plea today, and then I reset your case for sentencing. During that time period, I have the probation do a pre-sentence report, just so that I have more information when we come back. If for any reason at that time, there's something in that pre-sentence report that makes me say, you know what, I'm not going to follow this agreement. And what I do is allow you to withdraw your plea of guilty, and then we start all over. You go to trial, or y'all work something else out. I'm never just going to give you something if I don't agree with what that is. That's not how we do things. So if that helps with that understanding, I'm gonna let you visit with Mr. Lewis again, and go over that. But it's definitely I don't do that. I never have, and I never would do that. I don't think that's actually the right way to do it. So you're pleading guilty based on an agreement. And so if you don't take that agreement, or if I don't take that agreement, we'll start all over. Okay? All right, y'all go back and visit.
Oh.
Again, you're Joshua Smith.
Yes.
And Mr. Lewis, will your client waive more reading of the indictment?
You do.
Mr. Smith, in cause number 25, DCCR 1439, you're charged with the first degree felony offense of fraudulent use or possession of identifying information in the amount of 50 or more from August 20th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get that PSI done, and then we'll come back later for sentencing. Mr. Smith, what is your position with regard to bond based on that?
We're not opposed to a PSI bond on this, Judge. I believe there's a little bit of criminal history, but I think it'll be fine on this case.
So, Mr. Smith, what I'm going to do in your case is, based on the nature of your plea, is reduce your bond to $1,000. If you're able to make that bond, there's a couple of very important things about it, though. The first thing you do when you're released from custody, if you make that bond, is go to the probation department so you can get that pre-sentence.
All right, this is cause number 24, DCCR 0122, State of Texas versus Catherine Welch. Ma'am, are you Catherine Welch?
Yes, Your Honor.
And Ms. Welch is here with her attorney, Mr. Gertz. State's attorney is present. Ms. Welch was previously in court, entered a plea of guilty to driving while intoxicated, third or more, as well as a prior offense, which made it a second-degree felony offense. There was no agreement with regard to punishment. I have received the pre-sentence report, and has everyone had an opportunity to review that report?
We have, Judge.
I have, Your Honor.
Are there any additions or corrections to that report?
Not from the state, other than I want to acknowledge I have received Mr. Gertz's sentencing memorandum. So
I'm going to get to that too in just a second. Any additions or corrections?
Aside from the one comment that I make in the sentencing memoranda about a comment that she made about rehabilitation, I think it's more of a clarification, so I'm happy to touch on that. But other than that, we don't have any additions or corrections.
Okay. And Ms. Smallfino has already stated, as well as I received the sentencing memorandum at 5:47 p.m. yesterday. Going to point that out for the record.
The Harris County judge got her sentencing memoranda at midnight, so.
Well, it was reviewed quite early this morning, but I did review it. Ms. Smallfino, you've had time to review it as well?
same, Your Honor.
Okay. Other than that, I think you all should have a couple, there's only a few, but there were some jail incident reports that should have been provided to counsel. Did you both receive those as well?
Yes, Judge.
I did.
Okay. Is everyone ready to proceed with sentencing then?
Yes, Judge.
Yes.
All right. Mr. Gertz, do you have witnesses?
I'm not going to call any live witnesses unless the court requires it. When we have a person present from the Dream Center, if the court wants to inquire about that, I would essentially let her come up and talk if you want to have that conversation, but
Okay.
I think, you know, our focus here is going to be on the topics that we talked about or write about in the sentencing memo. And, you know, just sort of allowing, if the court decides to do what we're asking you to do, we are open and welcome to whatever the court requires of her
Sure.
to enter and successfully complete. We just wanted you to have that option on the table as well. That
Okay.
is an option that doesn't cost the court anything. Or
Right.
the state anything.
And for the record, I'm aware of the Dream Center and their program and what they do. And so if I have any specific questions, if we get to something where I would need that, then I appreciate them being here and I'll ask those questions. Ms. Malfino, does the state have any witnesses?
No.
All right, then argument.
Judge, I want to, I recognize this is a unique case and a unique ask that we're making here. This is not something small that we're asking for. I have sort of personally taken Catherine on over the last 3+ years, I guess almost 4 years, as a project for me, if that makes any sense. And what I mean by that is I really wanted to put to the test, could this person do everything that I asked her to do to at least get her an opportunity to be here in front of you asking what we're asking for? She exceeded my expectations by doing the 90-day inpatient rehabilitation. And while she was there, she started to explore with her counselors and her therapists there some of the underlying issues that went beyond just physical addiction, but actually had to do with her mental health and some of the things that she's experienced in her life. I'm not going to detail them on the record, but the court is aware of what those things are. Incredibly traumatic events that I think she had repressed and had never really addressed and explored. And so those counselors recommended not just aftercare, but a specific outpatient program to address some of the trauma issues that she's had. She went and checked into that program, stayed for basically a year, and again, did everything we asked her to do. When, you know, I told her to go get her own drug patch, I told her to go get her own interlock device. She did all of that. Those records should be attached to the memo. She was successful, has been following the rules, doing everything we've asked her to do, had been going to AA, had gotten a counselor, actually reached out and befriended the director of the Dream Center to try to figure out what she can do next to sort of commit herself to her sobriety and to fixing the mental health issues that I think stem from the challenges that she faced as a young person. Sometimes it's easy to look at one side of the ledger, the rap sheet or the criminal history, and think that defines this person. What I have been fortunate enough to do is to really dig down and get to understand her as a human, and see that all the progress she's made, all the effort she's made, and see what she's done well and all of the problems that she's been addressing well. She's obviously very anxious about this day, but we've been looking forward to this day as well, to be able to present that. And I want to go down on the bottom of page 2, address what I was talking about in the CSI. So that I'm not saying that this wasn't the words that came out of her mouth, but when she was asked by one of the examiners in the probation report, she felt she needed treatment. She said she didn't feel like she needed treatment. She wasn't opposed either. I want to clarify what we mean by that. And I say this here, but what she would say, I think, is she did 90 days of detox rehab related treatment, has continued aftercare, has continued mental health care. But in terms of going to a program that is specifically targeted at people who are currently using or currently intoxicated, I think she thought that wasn't the direction that would be ideal. She will do whatever you want her to do, but I wanted to explain what that comment means. And so, because a lot of times, as you know, Judge, private rehabilitation programs will just reject you if you've been clean for 3+ years, as she has. And so they just won't even accept you at all. So I think that was just a misunderstanding or a miscommunication between the probation officer and Catherine. But nonetheless, she's willing to do whatever the court chooses here. Additionally, we've been in contact with her current parole officer. They are willing to keep her on parole instead of revoking her, depending on what the court does here. And so that was encouraging as well. I think we had the same kinds of conversations with them about her recovery and about her efforts. And so I think that was an encouraging sign from them. And then finally, Judge, you see, we didn't want to focus too much on support from the community because, again, this isn't just a run-of-the-mill case. This is a different focus. But she is married. She has a family. She recognizes the impact that all of this has had on her family and her relationships, the strain it has put on her husband, both financially and also emotionally. And she accepts responsibility for that and is asking the court to consider this extremely rare position that we're asking the court to take here. Obviously, if the court would like her to address the court, she is happy to do that, or I'm not sure how you want to proceed on that.
Okay, thank you. Ms. Malfino?
Judge, I don't envy the position that the court is in this morning. I do take very seriously the comments of Mr. Burks. I take him at his word for that, and I hope that all of those things are true. It's difficult for me as a representative of Jefferson County and the state and the citizens that were on the roads every day to stand up and say I agree with probation, but I don't disagree with the things that Mr. Gertz has said and the information that is in his sentencing memo. To play the other side of the coin, does it suggest that she received the benefit of the doubt already by me waiving the habitual status that she could have been facing based on her number of priors? Does it seem in good conscience that I can say I ignore all of those priors? Absolutely not. But obviously, we have seen that her multiple trips to the penitentiary have resulted in no change of behavior until hopefully now in these last 3 years. And I do sympathize with Ms. Welch as an individual. Again, it's hard for me as a district attorney, assistant district attorney, to say that I concur with the punishment being probation, but I don't, again, disagree with the comments that Mr. Gertz has. We've had multiple conversations about this case. I know he's worked very diligently at it. I don't really know, Judge, and that's why it's before you, that putting her in prison for 20 years and her getting out in 2 versus an extensive probation period where she can continue the recovery she's been doing is a better option. But again, I don't know what is in the best interest of public safety. Unfortunately, none of us do. So I would defer to the court's wisdom and whatever you think is appropriate based on the volume of information that you have before you.
All right, thank you. Anything else?
Would you like to say something, Judge?
Your Honor, I just want to say that the past was fueled by drugs and alcohol. I take complete responsibility for that. I did not know from very young when things happened in my life that it could have been, some of it could have been treated and stopped earlier if I had gotten help for my mental health. That after I received this DWI, that helped me get myself to a place that I could go into a treatment program and deal with some of those past traumas. In the past, I didn't. I medicated and drank to just forget about the pain. just numb myself out. I didn't know how else to deal with that. And then when I got on my mental health meds, and I have bipolar, I have PTSD, and my mind back then was very chaotic. And I just want to say, after I had my mental health meds, I was able to go through treatment at Santa Maria in Houston, and that place really saved my life. I did extensive 90-day treatment with trauma counselors. It was a trauma-informed community there. And also, when I completed that, I worked an outpatient program, but I still lived on their facility. I went to the sex trafficking and recovery program, and I was in that for about 8 months, where I got the state paid for the counseling for trauma still. And I just worked really hard in that. I got a job while I was in there. And then once that program was over, I moved to a sober living facility in Oxford House in spring, and I worked there until I felt like I was strong enough to come home and do what I needed to do. And I was in the complete program for right out of a year. And I'm sorry, I'm very nervous today, and I know that my past record is, like Ryan said, atrocious. But you know, the things that I had to deal with within myself from when I was a little girl, those are things that you don't go to prison, even in their programs there, that you don't talk about. It's just, you just don't. And I'm asking you, please do not send me back to prison. I want to move forward. I have moved forward in my life, and this year that I've been in jail has given me more time to think and know that I am definitely headed in the right direction. I have a sponsor. I attend AA at home. I had moved on with my life as far as I could with my sobriety. I mean, I knew this charge was out there. And I think I made some really good choices with my Mid-County AA friends. They've helped me a lot. And I am open to anything. I will abide by all the rules and do anything that's asked of me. And I think, I know now that I'm responsible and capable of taking care of my business and my life.
Thank you. So, Ms. Welch, Ms. Malfino probably said it yet best, and I get this often, and they don't envy my position, and this is the worst part of my job. But I worked hard to get here, and it's my job. Part of my job, it's several things, and it's to look at, obviously defendants and giving chances and things like that, but it also is about making our community safe. And I have to look back. This is your 10th DWI. It's not your 5th. It's not your 8th. It's the 10th. And while I understand the trauma that you went through, that you've been to safe P3 times. You've been given opportunities on probation where they were revoked. You've had opportunities while you were on parole to do what you have done now. And while I appreciate what you've done, and I think that's great, and my goal isn't to, to stop any improvement, but I can't, in my opinion, in good faith, go home tonight, look myself in the mirror and say I gave somebody on their 10th DWI, that your last sentence was for 15 years in prison. The one before that was for 10. The one before that, you've gone to another 10 year back in 09. I mean, this goes back to the 90s. You got a 10-year sentence in 2011. While you're on parole for that one, you get another one. So they give you 15 years and you get out and you're on parole and you do it again. The fact is, we're just lucky that you haven't killed someone in our community 9 times over, being given opportunities. I just can't do it. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find and your plea of true to the prior offense. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. I'm going to sentence you to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed a trial court certification that shows this was not, well, I guess there was an agreement because the waiver of the enhancement, which could have been a 25 to life, as Mr. Gertz said. So I'm going to hand you the certification that shows this was an agreement. You've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Possession, because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You should read the written admonishment I provide you. If you have any questions about that, you can talk to Mr. Gertz. And Ms. Welch, I take no pleasure in this. This is extremely difficult for me. I understand to some extent addiction, and I understand that you are on a better path. However, there have been plenty of opportunities in the past where you were on a better path and you got back out and you got back on our roads again. And so good luck to you, ma'am. Thank you, Mr. Gertz and Ms. Malfino. Court will be adjourned.
This courtroom session ends with several very different outcomes and decisions. One defendant receives 1 year of deferred probation and a $500 fine on the deadly conduct case, with the possibility of dismissal if probation is successfully completed. Another defendant has probation revoked after admitting multiple violations, and the court reassesses punishment to 7 years in the Texas Department of Corrections, while also explaining the firearm restrictions that follow the judgment. Competency cases are handled separately, while Ms. McMillan's guilty plea is stopped after she says she did not commit the alleged offense, leading the court to set the matter for trial. Finally, Joshua Smith pleads guilty to fraudulent use or possession of identifying information, but the judge resets the case for sentencing so a pre-sentence investigation can be completed and reduces his bond to $1,000. Transcript ends there before that sentencing occurs.